Okay, we are back on the record in State versus Pritchett and Robinson. The jurors had 3 questions. One is there a police report from the incident? Second is, can we have an exhibit list? And the third says, count 4. Noah Walker testified that his wallet was stolen, but the indictment says his cell phone. Does it matter what item was stolen? The indictment does not match what the witness said. Question 1, is there a police report from the incident? Question 2, can we have an exhibit list? Question 3, about how the allegations in count 4 don't match up in the jurors' minds with the testimony from the alleged victim, Mr. Walker. I propose answering question 1 with language to the effect, and I'll write it on the back of the card and read it into the record. There may well be, but it is not in evidence, period. Any issue with something like that, Mr. Hiles?
No issue.
Ms. Mignot?
No issue.
Mr. Pritchett?
No, so you're saying it can't be entered into evidence?
Correct. We can't add anything more. The exhibit list, that won't be evidence. It may be that we get them an exhibit list, but if something wasn't tendered, and actually in the record is a police report, but it's not in the type of evidence that the jurors could get. Jurors very, very rarely get things like police reports because they are close to being continuing witness situations. So I'll write something to that effect, read it into the record. Mr. Hiles, I don't mind getting them if you have a clean. I wrote all over your exhibit list, and we have one from Ms. Mignot that I didn't write on, but not everything was admitted, and I don't want to send them an exhibit list that has items that weren't admitted for their consideration. So I'm inclined to say you have all the exhibits.
Yes. That's what my inclination, because the exhibit list I created, there was the way the trial went, I didn't put everything in, and I don't want to I think it's improper to bring to their attention other potential evidence.
Right. I mean, we could invest some time in editing your exhibit list to remove things that were not admitted, but we'd need to add you beyond the printed list that you got to the other side and to me. You added a few more, and then Ms. Mignot's is good to go. It just we need to remove stuff that wasn't admitted. And then there's that added complication of 1 through 4 were admitted for the record, but they're not going back there. I'm inclined to say you have all the exhibits. There's not a list of all of them. I'll word it better than that. Do you have any objection to that?
I don't.
Ms. Mignot?
I would agree with that. I would object to them getting some type of list, like the evidence.
Right. Okay. It's not like there are 1,000 exhibits in this one. So I think they can organize it. Last trial, I might have said, okay. Mr. Pritchett, do you have any objection to me saying, in effect, you don't get an exhibit list? Okay. Question 3. What do you say, Mr. Hiles? I don't have an indictment anymore. I had the, I can get it up on the screen here. In fact, why don't I share it so we're all looking at the same thing? Indictment. All right, on the screen is the indictment, and in particular, count 4, which charges the defendants with the armed robbery of Noah Walker. And the allegation is that his cell phone was taken. And the jurors are saying he testified that his wallet was taken and not his cell phone. I think the correct answer is, if the state hasn't proven that his cell phone was taken, then I'll word it differently, then the state hasn't proven that count. because it doesn't say anything about a wallet. And this isn't one where, hey, you misspelled Buckingham's name or left out part of his name. The allegation is cell phone. And that's not, they think, what Mr. Walker testified to. I remember one of the witnesses saying X was taken, and I looked at the indictment and said, that's not what the indictment says. And at least one of them said X and Y were taken, and the indictment said X, Y, and Z. That latter situation is not a problem because one or more of the items alleged, the victim said, no, that was taken from me at gunpoint. But one of them, and I'm guessing the jurors are right, that is Walker. That's why they take notes. Walker said they took X, and the indictment said Y is what was taken. So enough talking from me. Your thoughts?
I'm trying. He definitely said his wallet, but
it's not our job to say you're not remembering correctly. I need to respond to their question. Okay.
Yes.
I'm going to write something, I think, to the effect of if the state didn't prove what was alleged in the indictment, the state didn't prove the armed robbery. I can say if the indictment says X and they didn't prove X, then they didn't meet their burden. I think that's the legally correct answer. And then I'm not saying, are you sure that's what Walker said? Because I don't remember. Ms. Mignot, your thoughts about question 3.
I agree, Judge. I agree with the court's assessment a few seconds ago that telling them exactly what you just worded. Okay,
I'll wordsmith something. Mr. Pritchett, you adopt Ms. Mignot's response, or you have a different one? Okay. Yes, you adopt?
Yes.
Okay. All right. Let me craft some language and read it back into the record.
I wonder if Miss Monroe is like, hey, you're using my work product and not paying me. You can't just do that. You guys, I took the shortest of breaks. I took the shortest of breaks and saw motion as I was headed out to the Airbnb. I have like batteries in my hands to change the batteries in the in one of the devices out there, and and I see motion. I'm like, no, I need to go live now. So we didn't miss any audio, but yeah, didn't have time for an intro. Ashley did come in first in chat this time. Good job, Ashley. Congratulations. Judge is crafting a response. I'm not sure if he's going to read it back to the lawyers just for their final sign-off on it before he provides it to the jury. Had 3 questions from the jury. The first question, can we get an exhibit list? They said no. Let's see, what was question number 2? I know the third question was one of the defendants, on as far as charge number 4, the defendant testified that his cell phone or his wallet was stolen, and in the charge it says his cell phone was stolen, which would be, this is an error on the state's part, if so. But what was the second question? The reports, our police reports. They have access to reports of some sort, and the answer is no. They don't get those. He's going to read it into the record. I just don't know if it's going to happen here, like right now. Is there a police report from the incident, request for an exhibit list, and inquiries into count number 4? Thank you, Samantha, for the synopsis. Judge is wordsmithing as we speak. Maybe he's doing Wordle, but he's doing something with words. Valerie, this happens every time. As soon as I try to take a break, something happens. You guys should just kick me off as soon as verdict watch starts, and they'll return a verdict immediately. This jury did take notes. They were allowed to. And they were allowed to ask questions. But I'll tell you, if their question is on count number 4, I think they're taking the time, and I don't think we'll have a verdict today.
Question 1, is there a police report from the incident? Response: there are no police reports in the evidence you may consider. Any issue with that, Mr. Hiles?
No, Your Honor.
Ms. Mignot?
No, Your Honor.
Mr. Pritchett? Question 2, can we have an exhibits list?
No.
Response: you have all the exhibits. There is not an exhibit list. I hate writing that, but that's the answer. Mr. Hiles? No issue? Ms. Mignot?
No issue, Your Honor.
Mr. Pritchett?
No, but for the first one, you can't tell them that there is a report, but that there is none in the evidence that they can do.
That's what I said. There are no police reports in the evidence you may consider. They know they're police reports. You were holding them up, other people, they want them. Jurors always want the police reports. That's okay. Last question. It says count 4. Noah Walker testified that his wallet was stolen, but the indictment says his cell phone. Does it matter what item was stolen? The indictment does not match what the witness said. Answer: if the state alleged in the indictment that a specific item was taken, and you find that the evidence does not support that allegation, then the state has not met its burden. Mr. Hiles, any issue with that?
He's frustrated because
No issue. Well, I think some counts, like my only issue concern would be that, like you said, in other counts, there were some that listed 2
Or 3.
or 3.
We may have a follow-up question, and I'll need to deal with that. I agree with you. I couldn't come up with a different way.
Okay, yeah, that's, other than that, I have no objection.
Okay, I share your concern because this other count, if they are being that careful, and it's great that they are, and so they'll get to.
Judge, just stop talking. They're going to get to what? Which count?
Gattani, wallet and cell phone. And if he said, I think he actually said both those, but if he said one, we got Riggs, it's laptop, keys, and wallet. And maybe he said my keys and my laptop. They can ask, it's a different situation. But I think this addresses that situation.
I concur.
Ms. Mignot, any objection to that language?
No, Your Honor.
Okay. Mr. Pritchett, I feel like I'm interrupting you as you read the good word and we're working through this. Any objection to that answer? Okay. I'll have Deputy Gordon return those questions to the jurors.
Mr. Pritchett.
We'll make these part of the record once deliberations are complete. Hang loose, and I'll come back out when there's more.
Mr. Pritchett is doing a little Bible study.
All right.
Who goes first? Robinson. Okay, still deliberating. 2 hours, 20 minutes. Okay, here's what I'm going to do. I'm going to just leave this going. I'm going to do this right here because I've got to run out and do this thing at the Airbnb, but I swear as soon as I get up, something's going to happen. So we'll turn this one to camera 4. And we have audio turned on in case something happens. And then I just run. Just need to change the batteries in the door. That's all. Okay, they had 3 questions there. They had a question: can they have an exhibit list? They had a question about can they have the police reports? Police reports are hearsay. A hearsay, if you think about it, is any statement that's made outside of the court. Okay, so if it's not a witness sworn in under oath, sitting on the stand answering questions, it's hearsay. Now, a lot of the things, there are exceptions to a lot of different things, and so things that are hearsay can be brought in a lot of times if they meet one of those exception standards. But generally, police reports, hearsay. All right, I'm just gonna run. I'm just gonna run up and run. I'll mute my mic, but if they do something, you'll hear it. Here we go. I'll be right back.
Are we gonna address subject matter jurisdiction?
Okay, I'm back, but I'm also not back, so hold on one sec.
Alex stole it as well.
Have them send someone with more experience.
Because he's the guy.
I'm not a camel. Squirrel.
Is that
Somebody
correct?
just sent me a video of roaches fighting. I don't know who won.
Scratch all that. Oh, that was terrible. I apologize.
I was kicked back, taking it easy.
When are we gonna break for lunch, Judge?
The zombie apocalypse may be upon us. Alex stole it.
Have them send someone with more experience.
Because he's the guy.
All right. Okay, batteries changed, codes programmed. All right. My song said Southern Febreze can't save you unless Mrs. R.A. is by your side. Who needs to be put in timeout, Gailey May? Is everyone doing the sound effects? Sorry.
Somebody just sent me a video of roaches fighting. I don't know who won.
Somebody comments some little relevance. I like that one. All right. I'm still seeing some people in court, so I'm not ready to call a break here. I see defense sitting at the table. We see the clerk sitting up there, so I think they anticipate.
There's a lawsuit.
I think they anticipate being, yes, all of them. I'll turn them down a little bit.
This is not Burger King.
The accused closing was interesting. It had some elements that the judge had to sort of put a stop to, but it was better than you would expect from a pro se sov-sit defendant, I think you could say. Mrs. R.A. laughs at me and thinks it's silly and doesn't like rap music. They're anticipating a secondary question. See if it happens. Can you make commands explaining what normal court words mean, like hearsay and other words we may often hear in court? So like I could have like command hearsay and it would just pop up a definition of hearsay like that. I could do it. When he brought up the Constitution, by the way, slavery is still legal under the Constitution. That seemed odd to insert that there. It is a good idea, dog lover. I mean, obviously I have to do the work on that, but it's not at the top of my list. Why not just Google it? That works as well. We did a guilty, not guilty poll. I think about 54% said both were guilty, all charges. 14% said not guilty, both charges, and then there was a split percentage of that one would be guilty and the other would be not guilty. Yeah, his heart wasn't in it. Psychosaurus Rex. It's like he had been a recent convert to the sov-sit movement. Evie, I can tell you don't have YouTube Premium. The one benefit I love about YouTube Premium, well, there are two. First, no commercials. Second, that I can have background videos. I can have it play in the background while I do something else. Let's see the pre-word they used yesterday in the Kelly trial. The prejudice? Vicky, honestly, value for dollars for me, YouTube Premium is one of the top. I love it. And it does generate revenue as well for content creators. That is a good bonus as well. Like the prosecutor said, Mr. Pritchett is smart. He's a smart kid, and the prosecutor says it's a shame that he's that he's wasting that talent. It's also a taxable work expense. Yes. Vicky, they should. Let's get you monetized. All right. So now I see people in the courtroom, but it doesn't mean that necessarily that something's going to happen. So I'm going to let you guys talk amongst yourselves. I'm turning the sound effects down, way down, because I need to focus on the rap music. But I need to think to myself while I do this. So let's see here. I'm frustrated here. My poem, my song, it needs to. I could tell you what it is, but then it spoils parts of it. Do you guys want to be involved in the building of it and then hear the final product, or do you just want to be blown away by the amazingness of the final product? This is my dilemma. But I know you guys would be able to help me on the building side. Don't let RA steal your bars. Surprised is my vote. Involved, want to be involved. Okay, I'll involve you in little parts where I'm struggling. First of all, let me share with you the rhythm of the tune. And then I've got one more verse, so that's the rhythm we're sort of trying to match. And the line that I need to match with, so I need the line that goes before this. Hang on, it's not working. The case name in my story, is it a haiku? The case name in my story is The State of Denial versus One Big Deal. Because you got the state versus, and you got the state of denial. So I need that in there as my last line, but it's going to be an intro to set up the argument. Oh man. Okay, let me just leave that where it is right now. Sounds like homework. It is. Knox Hill? Man, sounds like a good channel. Sounds like homework as well. Cass, this is one of my great lines. And this is the shade, but the line says, "Tell the lawyers to sit down and listen to the pros say." I'm so proud of that line. It's ridiculous. But tell the lawyers to sit down and listen to the pros say, and then it's me saying some more in the next verse. But reading all your suggestions. Victoria, a question actually about court. I'll answer that during deliberations. They're allowed to go as late as 7 p.m. Eastern time. So we're at 5 right now. It means they have an hour and 45 minutes left. I don't think we're going to have a verdict tonight. I don't think that's going to happen. Can I just say this picture in the top left-hand corner? If that's how close jury members have to sit next to each other for the entire trial, count me out. I'd be like, Judge, I need my own seat. I need some room. I need to stretch out. I need to be able to wave my elbows and not elbow somebody. I like that Vicky is literally poaching lines from chat for a competing rap. I love it. It's a perfect line. I should write a line, have to use one for chat. The next line. No. I need my creative liberties. Police chase on KTVU? Let me check out KTVU really quickly, see what's happening there. In the Bay Area. I think I've got it here. Just one second. It looks like a guy is just walking along the street. Is that the right one? Is this the police chase? Is that our perp? Our suspected perp? Not sure what's going on here, but it looks like he's trying to get into a locked area. He's just chilling on the steps there. How do we know this is a police chase? How do we know this isn't just the helicopter pilot being bored and following random citizens around town? They let him in. Okay, helicopter, you're rotating us right out of position. There must be more than one helicopter up in the air, and they've got to follow a flight pattern. I don't think I can go back 10 minutes. Let's see. Let me see if I can show both at the same time. Give me a second. We're going to bring this back and bring in the other camera on top. Super source. Camera 2 will be box 3. Okay, we'll leave this guy right here. Not sure what's going on. He's leaving. Jury's coming up on 3 hours of deliberation. Helicopter's like, never mind. We just followed some random guy around the hood, and he was getting some barbecue or something. Car problems. Looks like he's getting into a car. Is this the beginning of the chase or the end? And where are the police? Just spying on random people. Hey, it's out in public. It's out in public. Supreme Court has ruled that if you can see it from public, like an airplane, it's fair game. I've got no audio.
This is not Burger King. People do not get to have it their way.
I feel like I'm watching like what happened before the police chase. Thomas, do you know where this is or what the story is? Let's see. I just got a live police chase in SF. That's it. It's like the Truman Show. I mean, the driving's poor. The parking's poor, too. Holy cow. This neighborhood's awful. It's in California. The guy went into someone's house, and now they're driving another vehicle. Okay. Thomas is going to come on to either narrate or explain himself. Thomas, you're live.
Hey.
You're live on the air. Is that
Okay.
Okay.
Yeah, absolutely. Little background. So prior in this chase, the suspect was in a black Chevy Trailblazer, the SS model. Mm-hmm. So it's pretty sharp. Police backed off, but the helicopter stayed on. He stopped in another neighborhood, opened his door, and just had a quick conversation with someone that was there. And he shut the door and he took off again and went to this neighborhood. He got out of his car, which was kind of blocked from under some trees. And then that's where you picked it up when he was just kind of mingling around that house on his phone. And so now he's in a different car with a friend or buddy or whatever. So police have been spotted in the last like 20 minutes of this chase. And it's up in San Francisco, California.
Do we know what the want is? Why were they chasing him to begin with?
Nope, I hopped in too late when he was booking it down, and the police were just being called off. So it's all a little bit of a mystery. And when I first saw it, there was no audio at that time either. So
I swear, this is Truman Show level. Helicopter pilot is bored. He's just like, let's follow a random citizen throughout his day, and just and we'll put breaking news, police chase up on the screen, and just see what people watch.
Well, he's got 580 of us in here watching it with you, so they did good. So,
I'm intrigued. Now I need to know what happens. I need to know,
So
this is crazy.
It'll be interesting to see if the helicopter continues calling in their location, and then all of a sudden out of nowhere we see cops can pull up. But right there in the screen, you can see a different helicopter, the shadow across the road.
Yeah.
So it looks like law enforcement is still there in the air. I wonder if his buddy even realizes what's going on, or if he thinks
he's like clueless. It's like,
yeah,
well, lots of helicopters out and about today, huh? Yep.
And then all of a sudden, 20 squad cars are going to stop in front of them. That's going to be hilarious.
Yeah, it's like full SWAT, felony takedown. While you're on the air, did you want to tease a little bit what we have going on tomorrow for the podcast? Or Thursday, excuse me. Thursday for the podcast.
I was going to say, well, surprise to me that we're doing it tomorrow. But yeah, so the Thursday, most of you that watch the podcast, you have seen our guest Roy before, the retired principal, and has become just a friend in general to hang out and chat. And the officer Brian, who's on last week, the week prior, he wants to come back and hang out. So it'll be a little different, not so much of interviewing the two of them, since we've already kind of get to know who they are. They're just going to come hang out and enjoy the podcast and give their input and funny news stories or funny other stories they want to share for the evening. So it'll just be kind of a 4-person show, and they are really, really excited.
It's awesome. I cannot wait. So we'll have some of the funny stories, the traditional stuff that you're used to on the podcast. But we'll have 2 more familiar faces to add
That's
funny
right.
commentary.
And we may or may not throw in a fun little 2 versus 2 version of charades or something of that nature for chat to tease and make fun of us for ultimately failing at as we try it.
Lots of failure will happen. I'm telling you. I'm not a charades person. I'm bad at guessing, and I'm bad at acting it out.
That's me too. So epic failure is what the people want, so they're going to get it. So we're ready. The neighborhood that they're driving through right now, this is where he had stopped at one point in time earlier and opened his door to talk to someone, because then he took off at a high rate of speed over those exact speed bumps. So they're doing familiar things that they did earlier and backtracking a little bit. So this could be fun or dead.
Yeah, it's interesting that the police have shown very little interest in the vehicle and had plenty of opportunity. I mean, you've got fairly heavy traffic. Small roads like this, it's easy to block a car in, but you'll see.
So,
well, great. I'll let you get back to work. I know you're busy. Appreciate you. Looking forward
sounds
to Thursday.
Good.
We'll
Thanks, Scott.
Bye.
Me too. Bye-bye.
All right, so we may or may not be watching a police chase. We might just be watching someone drive to work right now, or get a ride from a friend to work. It's like a day in the life in the average Uber driver, I think is probably what we have right here. The driver hasn't left the scene, apparently, according to Thomas there. He says this is sort of the area he was at before when the police were chasing him, but this is a different vehicle now. I think what's most likely going to happen is a more compelling or a higher speed chase is going to pull the helicopter off this one. We're going to go somewhere else and watch another one, is my guess. Wendy's or Krispy Kreme? I don't know. They seem to be driving too slow. Oh, look at that. Look at that. Cops are here. Cops are here. And he's running. We have a runner. I think he went in the house. Now the friend's like, oh, great, I just participated in a crime and didn't know it. Deploy Officer Barkham's. Sorry, let's do a full screen on this. Sorry, there we go. I think he ran into the house. Nope. Well, that's not him. That's just random citizen. We're not going to switch to a new random citizen right now. Yes, it's going to be the first podcast of the month. 10 new memberships given away.
People do not get to have it their way.
We don't know why he's being chased. It's been a lengthy chase involving multiple vehicles. And now there's only one officer here to pick him up. Don't see anything in the backyard. I think he's in the house.
There's a lawsuit.
How many rotations do you think it'll take before he comes out of the house? Okay, backups arrived. Let's see what urgency they deploy with. Some neighbors are standing around trying to see what's happening. Only 2 squad cars at the moment. Don't think he's in the backyard. I think he ran up the porch to get sort of into the house. That's the wrong house. There you go. More cars. Oh, they got him. They got him. Boom. There he is. I think he's being read his rights right now. Nope. Just being searched. Is someone barefoot? No, the officer was standing on something on the ground like a piece of garbage. It looked like he was wearing no shoes, but
There's a lawsuit.
apparently the chase is over. That was it. Not sure what that was about, but neighbors come in to straighten everything out. Explain everything to the police officers. Looks like no injuries, no damage. I'm not sure what happened previously in the chase, but the driver friend got away. So we're done, I guess. There you go. Just past the 3-hour mark. Still no action in the courtroom. I don't think we will, honestly. Pops has arrived. Covered it up, top left pick. Is that Michael Portillo, back row, second left? I don't know who that is. Looks like a stock photo of what a jury's supposed to be. Now we're looking for another random citizen to follow. Oh, they got the other car too. Look at that. They got the driver. LB, I know. It was hard to contain myself during the more dangerous parts of that chase. was just on the edge of my seat throughout it. Seriously, is that the best they can offer us today? We're in verdict watch. We need a little bit more action than that. So the other driver made it, what, 15 feet? Zero Mountain Dew today, Judy, or yesterday. Weather Watch says we'll never recommend another chase. The good part was what we missed. Deliberations today can go as late as 7 p.m., which gives them another hour and 20 minutes before they need to make a decision. No caffeine today. Was entertaining. It was Truman Show level, but it was entertaining. Okay, that's all. I do have a car. I can make our own chase. Here's the problem, James. My state, North Carolina, does not release police footage unless they want to. If they want to release it, that's fine. But if you ask for it, the answer is no. You could be the defendant in a criminal trial with body cam or dash cam footage of an event that you're accused of, committing a crime in. And if you ask to get a copy of it, they will allow you to view it without recording it in a controlled environment, and that's it. I'd hate to respond to this one, Jim Bob, because as soon as I say something, then it's a jinx. But I currently have a crystal clean record. Nothing, no accidents, no tickets, no parking violations, no parallel parking. No improper lane position. And this is pure luck, I say, because I drove my car for a year with the wrong tags. Did StreamYard get sold? They haven't changed their name if they did. Who'd they sell out to? Hopin buys live streaming startup StreamYard for $250 million. But that was back in 2021. Hopin's StreamYard products to be acquired by, let's see, this is April 9th. This is a new one. By Bending Spoons. Bending Spoons is going to buy StreamYard, and it's an AI-focused software company. You're going to buy StreamYard, Streamable, and Superwave. Hope they don't screw it up. I've never heard of Bending Spoons before, but apparently they can do it with their mind. See, while we wait, Daybell's back in court tomorrow, 10:30 Eastern on our second channel, Top Mark Media. That'll be great. I think I just missed a call. Sorry about that. So we'll have that tomorrow over there. Vicky, get some sleep. It's going to be tomorrow, I think, before anything happens. Right now, we've got an hour and 15 minutes before the courthouse closes. So I think they're going to be going home here soon. Jen, I think that is a real jury deliberating, but it's not our jury. D-Nick, you feel invisible in chat? You should not. You should not. We see you. Waiting for the helicopter to move on to something else, but apparently this is the most exciting thing happening out of LA today. It's a good day. That does sort of look like Becky Hill in the bottom right-hand corner picture. Air unit's talking about another pursuit. Which air unit? Let me see if we can join them. The audio might be more interesting. Oop, there we go. Camera's been locked and stowed in the upright position, ready for landing. You've seen that little glass jar, that little tube, plexiglass tube. That antenna that's in there is pointed back towards the station, and it beams the signal from the video back towards the station. So as the helicopter is flying, it tries to maintain the direction to keep the signal going.
Marijuana as a less
that audio that just came in there. Yeah, that was the story I saw this morning. If you guys saw this, assuming as we had a case that was talking about drug use and it had marijuana in it, apparently the federal government in the United States is going to be reclassifying marijuana. So it's not like a Schedule I drug anymore. So it would be less of a severe crime for it. Or possibly even not illegal federally at all. We'll see what happens. All right. Nothing in court. Nothing exciting, but the lyric writing is not going as fast as it did the other day. So let me close that one. What else do we have? See if anything's happening up in Thurston right now. We do have some Thurston County stuff to watch. Let's see what's up here.
Never mind.
And Mr. Iverson is, I saw a head nod, I think. That's your name, is Zachary Iverson?
Yes, Your Honor.
Yeah, there we go. Okay, thank you. And Mr. Iverson, did you have a chance to go over your constitutional rights with Ms. Capone?
Yes, I did.
Any questions for me about those rights?
No questions.
Okay. You're just about to turn 21, right?
Yes.
Okay. And Ms. Capone, is there any objection to probable cause today?
Your Honor, I'm not testing probable cause for today's purposes. And Mr. Iverson will be asking for court-appointed counsel. He's not working. He lacks stable housing. So I believe he qualifies.
All right, thank you.
I also have his assets.
Thank you. We'll note probable cause on a charge of assault 4th degree and a not guilty plea for Mr. Iverson to that charge. I will appoint counsel to represent Mr. Iverson.
Cole's iPhone down there. Guy's sitting on a camp chair out by the river, probably got a fishing pole in the water. Puffing
The
on a
alleged
Cuban.
victim in this case, Mr. Thornton, what's the relationship to Mr. Iverson?
Your Honor, Miss Sheila King is here to represent the victim, and James Thornton's wife, Helena, is here. My understanding is, I believe that it's a either a son or grandson relationship, but let me verify that.
All right. Ms. Thornton, you are muted currently. And Ms. King, feel free to weigh in.
Good afternoon, Your Honor.
Good afternoon.
Miss Helena Thornton is here to speak on behalf of Mr. James Thornton today.
All right, thank you. And Ms. Thornton, thank you for being here.
Thank you.
All right. And so is this grandson's relationship? Is that what we have here?
It is. It's my grandson.
Okay. There's a
I
dog.
help
Okay. Or is that a
raise
sheep? I can't tell.
All right.
Is that a squirrel or a cat?
Okay.
Oh, it's a cat.
And Mr. Holcomb states position on release.
Your Honor, the state's position on release is no new law violations and abiding by the no contact order that's in the judge's folder. I believe that Miss Helena Thornton will have a comment on this. However, the reason for the no contact order, Your Honor, is the defendant in this case is alleged to have said that both Helena and James Thornton should die and go to hell. The defendant shoved the victim, James Thornton, and struck the victim on the side of the face while trying to grab James' phone. The victim, James Thornton, explicitly asked the officers at the time for a no contact order. And at the time, Mr. Thornton was actually on the phone trying to contact law enforcement. And my understanding is that the defendant's temper and behavior at the time was very concerning. So that's why the state believes that a no contact order is appropriate in this case.
All right, thank you. Ms. Thornton?
Yes.
Anything? What's your thought on a no contact order?
I think it's appropriate. And attacking grandpa and threatening our lives, it's we cannot have him in our house at this point. And I also wanted to add that Zachary in general is not a violent person, but he is on a spectrum. He has Asperger's and he's using drugs extensively. And I also believe that because of his Asperger's, he's prone to addictions. And he needs desperately evaluation and help. And I am not equipped to help him at this point because his behavior is getting worse and worse and escalates to the point that we cannot deal with it anymore.
All right. Thank you very much. And Ms. Capone?
Your Honor, I'll be asking the court to release Mr. Iverson on his own recognizance. It sounds like the state is in agreement, or at least not objecting to that. Mr. Iverson's not working. Again, he doesn't have stable housing. He has no criminal history, no warrant history, so I think it's fair and appropriate to release him today. Mr. Iverson is entitled to the least restrictive conditions of release, so I'd be objecting to no contact order. But understanding that the court may want to impose one, I have advised him on that
Judge is
issue.
watching the cat.
Thank you.
He's watching the guy with the cat. That's it. It's like, oh, okay. What?
Your Honor, given the representations of the victim, I don't know if the court would be willing to consider UAs.
All right, thank you.
And Your Honor, if the court is considering that, I'd like to respond.
All right, thank you. And Ms. Thornton, were you present at the time this happened?
Yes.
And is your belief that your grandson was under the influence or not under the influence at the time this happened?
He is always under influence. I don't know who is giving him drugs and what kind of drugs, but his behavior is worse and worse. He needs help. He cannot help himself. Your Honor, you can order him not to stop using it, but he will not. He is incapable to do it by himself. And I don't know what to do to release him. Where are you going to release him? On the street? He's incapable to live on the street.
All right. Thank you, Ms. Thornton. Ms. Capone?
Your Honor, I don't know that UAs are appropriate under these circumstances. Nothing about substance use is alleged in the police report. And whether or not Mr. Iverson will be successful living on the streets is not a consideration under 3.2. I have a list of resources to provide Mr. Iverson, understanding that he may be without housing upon the entry of a no contact order, but I would object to imposition of UAs at this time. If the court would like to readdress it when new information comes forward, I believe then it would be appropriate.
All right. Yeah, I see it differently. We have direct information from Ms. Thornton, who indicates she was present at this time and says this is a persistent problem. So that's satisfactory for the court to base release conditions on. And I will note that it's in my hearing of what Ms. Thornton's saying, she's not saying this to punish Mr. Iverson. She's saying it because she believes he needs help, and it's a therapeutic idea, not a punishment idea. So she's not here advocating to have him punished. She's trying to get him help. He may not want the help, but she's trying to get him help. All right, Mr. Iverson, I am going to release you. There's no basis under your criminal history for me to hold you, and we don't have other places that can provide the service that you might need. Unfortunately, that's just not available in our community or probably in most communities. So your grandma clearly loves you. She took the time to be here. But she's very concerned by your drug use, which she believes has really exacerbated some behavioral tendencies that make them afraid of you. And I suspect that you don't like them to have to be afraid of you. So no criminal law violations. You're to have no alcohol, no marijuana, no any other drug. And you're not to possess a firearm or other dangerous weapon. And I am going to order that you do your analysis or breath test as directed because you're going to be on pretrial services supervision. You're to report into pretrial services as they direct, and you have to report to them no later initially than by close of business on Thursday. There's a phone number on this form, and it's your job to call them and then report back to them as they direct. And if they want you to do your UAs, they're going to have you come in and you have to show up to do those. You understand all that? Is that a yes? Need to say it.
That was my fault, Your Honor. We were muted.
Okay, thank you. Thank you. And you're coming back on the 12th of June at 10 o'clock in the morning. What's that? Oh, yeah. All right, we will see you then. Thank you, Mr. Iverson. And Ms. Thornton, you're welcome to participate in that hearing as well.
I will. I have the best interest for him, and releasing
Yes.
him on the street is not to his best interest, Your Honor.
I would agree with you. As I said, though, we don't have many other options at this point. So we are going to try to provide some resources. All right.
Thank you.
Now calling the cat guy. Where's the cat guy? Cole. Trying to just cover the judge box.
And for the folks waiting for the 2:30 calendar, which are a number of you, we still have a number of cases we have to get from our 1:30 calendar. So you just sit tight where you are. Ms. Capone.
Your Honor, I believe present at Nisqually is Mr. Campos.
Okay. All right, thank you.
This is Thurston County. Yeah, I think it's District 4, District 2.
All right, maybe. And it's Joseph Charles Campos. Is that right, Mr. Campos?
Yes, Your Honor.
Okay, thank you. And do you have a specific mailing address or?
No, I do not, Your Honor.
Okay.
So
How about a cell phone?
bun.
I know I do not.
Okay. And did you have a chance to go over your constitutional rights with Ms. Capone?
Yes.
Any questions for me about those rights?
No, Your Honor.
Be with you in just a moment.
Three and a half hours of deliberation.
And Ms. Capone, any objection, probable cause?
Not contesting probable cause for today's purposes, Your Honor. We'd ask the court to appoint counsel for my office. Mr. Campos is unemployed and unhoused. He does receive food stamps.
Thank you. Find probable cause on a charge of theft, 3rd degree, enter a not guilty plea for Mr. Campos to that charge. I will appoint counsel to represent Mr. Campos. And I see an active warrant out of Clark County on a malicious mischief charge. Mr. Holcomb, city's position on release.
Your Honor, as the court noted, the defendant does have an active warrant, but outside of that active warrant, the defendant has no other criminal history in the state of Washington. And I haven't done a out-of-state criminal history given the nature of the charge for this case. So given the defendant's very limited history within the state of Washington, the state at this time does not have any objection to personal recognizance so long as the defendant doesn't commit any new law violations and stays away from the Safeway on 502 Cleveland. The state would also highly recommend that the court have the defendant check in with pretrial services, given the defendant is incapable of providing a stable phone number or address for court reminders. The fear I have at this point, Your Honor, is that I don't know if the defendant will show up to future court dates, given the situation he's in and the fact that he only has the one active warrant, but it was 2 months ago. And the only issue I see is that if he's released into the exact same conditions that he had under which he got that warrant without any other form of supervision, then he's also likely not to show up for either this or the other court appearance.
Thank you. Ms. Capone?
Your Honor, I'm asking that Mr. Campos be released on his own recognizance. No objection to a stay, but I would object to pretrial services supervision. Mr. Campos has no convictions in his history, and based on my reading of the Clark County docket notes, it's quite possible and quite unclear if Mr. Campos even got notice of that hearing. So I would argue that we shouldn't be holding Mr. Campos accountable for an FDA if he didn't even get notice of it. I point out the allegations here are of theft for basically food totaling less than $20 a day, or $20 to create some perspective. A Pierce County study said that incarcerated individuals, it costs counties more than $100 to keep people incarcerated. And I think that given the nonviolent nature of the allegations, the fact that they are merely allegations at this point and that Mr. Campos has no history, I'd ask that he be released with a court date.
All right, thank you. Yeah, although I think essentially what you were telling me feeds into Mr. Holcomb's argument, which is there is no other way to provide notice to Mr. Campos, and that's why Mr. Holcomb was suggesting you report to pretrial services. So I think that argument cuts both ways, and I frankly thought that was a good idea. So I will do so. So I will authorize your release, Mr. Campos. You're to have no contact with Safeway store, no criminal law violations. I do want you contacting pretrial services. It's the only way we have to stay in touch with you. If you get a cell phone and you give us the phone number for texting, then we can stop you having to report to pretrial services. If you get an address that you legitimately get mail at, then we can not have you report to pretrial services. But for now, that's the best option. I also want you to clear that Clark County warrant. And I'll give you a court date. And coming back on the 12th of June at 10 o'clock in the morning.
Okay.
Okay, so tell me what day you're due back here.
June 12th.
June 12th. What time?
8:30.
No, 10 o'clock.
Oh, 10 o'clock. Okay, sorry. I didn't hear the exact time. Sorry about that, Your Honor. 10 o'clock. I got it.
All right. June 12th, 10 o'clock.
All right.
Okay.
You should also get written notice, right?
I'm sorry.
You should also be given written notice.
You're going to get a copy of the document I'm signing that has that information on it, but I just want to make sure it's imprinted on your brain card.
Got it. June 12th, 10 o'clock.
Yep. Okay. All right. We'll see you then.
All right. Thank you, Your Honor.
You're welcome.
They're not. Nobody's very confident that that's actually going to happen, but.
And Your Honor, whenever the court's ready, I can make a record on Miss Creighton.
Okay. Unina Creighton? Yes, go ahead.
I spoke with Miss Creighton in a breakout room earlier. She is very ill and would like the opportunity to address the court tomorrow. So I'd ask that this be set over with the warrant amount to remain.
Okay. And are you going to be filing at 1077 or?
Not at this time, Your Honor.
Okay. All right, I'll hold her without bail and we'll set her on for tomorrow.
We're back in court. We're back in court. Here we go. We've got some action. Wait, well, tell you what. Let's keep this going because we might have
I
Cole.
can address those
We've got
matters
the audio
here
from
from
the other court
jail,
too.
or I can drive over to the court, whatever Your Honor wants me to do.
I mean, we're fine with you doing it from right where you are if the jail doesn't evict you.
As long as we don't go too long, I don't think they'll mind.
Yeah. I know what happened last night, so, but hopefully we'll be done well before you reach that hour. And I'll be with you as soon as I get Ms. Creighton's form set up.
Waiting for Cole to come back on screen with a new pet. I'm thinking possible parrot. Thinking blue and gold macaw. Or yellow and gold. What is it? Yeah, blue and gold macaw.
Tomorrow at 1:30, I assume.
Tomorrow at 1:30, yes.
Ooh, Judge adjusts the camera for us. Gives us the old view. Goldfish.
And
maybe?
what do we know about Mark Jeremy Bay? Oh, it's president in court. Mr. Bay, come on up.
He's like, I'm right here. Boa constrictor.
And Your Honor, I think it may be wise if I speak with him before court today.
Okay, I think you're probably correct about that. So, Mr. Bay, all that, let me confirm a couple things and then I'm going to have you speak to Ms. Capone. 21715 North Clear Lake Boulevard?
Yes, sir.
Okay. And how about a cell phone number?
253-606-6331.
Okay, thank you. And if you'll step outside into the lobby, we'll get you in a breakout room with Ms. Capone.
Thank you, Your Honor.
Your Honor, could I inquire whether my client is present for a
It's
warrant
Attorney
warrant?
Rowe.
Ms. Rowe, who is your client?
Always safe space. And then when we're doing the whole thank you, whatever, then
okay, now we're gonna go full
she can
screen
come out.
Oh my goodness.
Yeah.
That was
Correct.
one that beat,
Right.
We're gonna have very little notice if this is a verdict, but I don't think it is. We have Max, just Max, and Mr. Richardson.
I mean, no, but it's all the same. Gotta work on when they gotta work on this very life longer.
All right, well, let's get on the record. It's late and we've got jurors who've been here all day. We're back with State of Georgia versus Robinson and Pritchett. Deputy Gordon tells me that the jurors have reached a verdict as to both defendants. Ms. Mignot, is there anything that we need to talk about before we bring the jurors out?
No, Your Honor.
Okay. Mr. Pritchett, anything we need to talk about before we bring the jurors out? All right, let's bring the jurors out.
We have a verdict. We have a verdict in the trial. Wow. Wow. With just 45 minutes left in the day in the jurors' time, they were able to reach a verdict after 3 hours and 40 minutes of deliberation time. So they were able to reach verdicts in both cases, meaning they've been able to reach a guilty or not guilty to every charge that each defendant is facing. Mr. Robinson does not seem to be looking at the jury. Interesting tactic.
It's the right count. All right, you all can be seated. Could the foreperson please stand? The foreperson. Have you and your colleagues on the jury reached a verdict as to defendant Pritchett?
Yeah.
Have you also reached a verdict as to defendant Robinson? And is it a unanimous verdict?
Yes.
Did you sign and fill out the verdict form on behalf of your colleagues?
Yes.
All right, if you would hand the verdict forms to Deputy Gordon, we'll hand them to me.
Counsel's just arriving. The prosecutor's just arriving. Bailiffs are standing by because pretty sure there's some minimums.
Gordon, if we return them to the foreperson. I will ask you now to publish the verdict, which simply means read in the verdict as to each count, starting with either defendant, but make clear for the record which defendant you are providing the verdict for, and we'll go from there.
Okay. For Tyrone Robinson, count 1, home invasion, we find defendant Robinson guilty. Count 2, armed robbery, Carmody, we find defendant Robinson guilty. Count 3, armed robbery, Hooper, we find defendant Robinson guilty. Count 4, armed robbery, Walker, we find defendant Robinson not guilty. Count 5, armed robbery, Mears, we find defendant Robinson not guilty. Count 6, armed robbery, Buckingham, we find defendant Robinson guilty. Count 7, armed robbery, Gattani, we find defendant Robinson guilty. Count 8, armed robbery, Riggs, we find defendant Robinson not guilty. Count 9, aggravated assault, Carmody, we find defendant Robinson guilty. Count 10, aggravated assault, Walker, we find defendant Robinson guilty. Count 11, aggravated assault, Mears, we find defendant Robinson guilty. Count 12, aggravated assault, Buckingham, we find defendant Robinson guilty. Count 13, aggravated assault, Gattani, we find defendant Robinson guilty. Count 14, aggravated assault, Riggs, we find defendant Robinson guilty. Count 15, aggravated assault, Hooper, we find defendant Robinson guilty. Count 16, aggravated battery, Gattani, we find defendant Robinson guilty. Count 18, participation in criminal street gang activity, we find defendant Robinson guilty. Count 19, possession of firearm during commission of felony, we find defendant Robinson guilty.
Thank you, sir. And if you would turn to the verdict for defendant Pritchett.
Count 1, home invasion, we find defendant Pritchett guilty. Count 2, armed robbery, Carmody, we find defendant Pritchett guilty. Count 3, armed robbery, Hooper, we find defendant Pritchett guilty. Count 4, armed robbery, Walker, we find defendant Pritchett not guilty. Count 5, armed robbery, Mears, we find defendant Pritchett not guilty. Count 6, armed robbery, Buckingham, we find defendant Pritchett guilty. Count 7, armed robbery, Gattani, we find defendant Pritchett guilty. Count 8, armed robbery, Riggs, we find defendant Pritchett not guilty. Count 9, aggravated assault, Carmody, we find defendant Pritchett guilty. Count 10, aggravated assault, Walker, we find defendant Pritchett guilty. Count 11, aggravated assault, Mears, we find defendant Pritchett guilty. Count 12, aggravated assault, Buckingham, we find defendant Pritchett guilty. Count 13, aggravated assault, Gattani, we find defendant Pritchett guilty. Count 14, aggravated assault, Riggs, we find defendant Pritchett guilty. Count 15, aggravated assault, Hooper, we find defendant Pritchett guilty. Count 16, aggravated battery, Gattani, we find defendant Pritchett guilty. Count 18, participation in criminal street gang activity, we find defendant Pritchett guilty. Count 19, possession of firearm during commission of felony, we find defendant Pritchett guilty. Count 20, possession of firearm by first offender probationer, we find defendant Pritchett guilty.
Thank you, sir. Deputy Gordon, if you would please share that verdict form with Mr. Hiles, Ms. Mignot, and Mr. Pritchett.
Mr. Pritchett should be uncuffed so he can review it. Sort of a unique situation there. This means that the state failed to meet their burden of proof.
Mr. Hiles, do you have any objection to the form of the verdict?
Yeah, Your Honor.
At least to a couple charges.
As to either defendant.
Yeah, Your Honor.
I would say that it sounds like the charges that were related to specific individuals were not proven. Like the jury was taking notes and they missed, like a piece of evidence was not provided, apparently. He has to flip the pages for him.
Ms. Mignot, I can't tell if you're still looking at the verdict form. Did you get a chance to look at it? Okay.
With Mr. Pritchett.
Got it. Do you have any objection to the form of the verdict?
No, Your Honor.
So 4 counts were not guilty, and that was uniform on both. I think it had to do with possibly the wording of the indictment, the wording of the charge.
Mr. Pritchett, do you have any objection to the form of your verdict? Okay. Mr. Hiles, anything else before I excuse the jury?
Not from the state.
Ms. Mignot?
We'd like the jurors poll.
Okay. Ladies and gentlemen, polling of the jury is simply, I'm going to call each of you one by one. I'll just use your last name and ask you the same 3 questions. And so when I do call your name, if you would stand, I'll ask you the 3 questions. We'll see what your answers are, and we'll work through it that way. Juror number 1 is Watson. Oh, that's who we excused. Like, that was going to be awkward. Long gone. I'm like, I don't remember interacting with her. How about juror 2, Shane? All right, bumpy start here, not your fault, because Watson didn't stand up. Was the verdict you just heard in court your verdict in the jury room as to both Robinson and Pritchett?
Yes.
And was it freely and voluntarily entered into?
Yes.
Is it still your verdict?
Yes.
Thank you. Next is Ms. Anderson. Ms. Anderson, was the verdict you heard here as to Pritchett and Robinson your verdict in the jury room? Did you freely and voluntarily enter into those verdicts? Do they remain your verdicts? Thank you. Juror 4, Taylor. Sir, were the verdicts you read in court your verdicts in the jury room?
Yes.
Did you freely and voluntarily enter into them?
Yes.
Are they still your verdicts?
Yes.
Thank you. Juror 5, Ms. Martin. Were the verdicts read here in court your verdicts in the jury room?
Yes.
Did you freely and voluntarily enter into those?
Yes.
Are they still your verdicts? Thank you. Juror 6, Ms. Freed. Were the verdicts read here in court your verdicts in the jury room? Did you freely and voluntarily enter into those? Do they remain your verdicts? Thank you. Mr. Frank. Were the verdicts read in court your verdicts in the jury room?
Yes.
Did you freely and voluntarily enter into them?
Yes.
Do they remain your verdicts?
Yes.
Thank you. Juror Stanley. Were the verdicts read here in open court your verdicts in the jury room? Did you freely and voluntarily enter into them? Are they still your verdicts? Thank you. Juror Lynch. Were the verdicts read here in court your verdicts in the jury room?
Yes.
Did you freely and voluntarily enter into them?
Yes.
Do they remain your verdicts?
Yes.
Thank you. Juror Johnston. Were the verdicts read in court your verdicts in the jury room?
Yes.
And are those things you freely and voluntarily joined?
Yes.
Do they remain your verdicts?
Yes.
Thank you. Juror Karras. Were the verdicts read in court your verdicts in the jury room?
Yes.
Did you freely and voluntarily enter into them?
Yes.
Are they still your verdicts? Juror Hinner. Were the verdicts read in court your verdicts in the jury room?
Yes.
And did you freely and voluntarily enter into them?
Yes.
Are they still your verdicts?
Yes.
Thank you. Juror Goodwin. Were the verdicts read in court your verdicts in the jury room?
Yes.
Did you freely and voluntarily enter into them?
Yes.
Do they remain your verdicts?
Yes.
Almost done.
Ms. Mignot, anything else from the jury before I excuse them?
Not from the jury, Your Honor.
Okay. Mr. Pritchett, anything else before I excuse the jury? All right. Ladies and gentlemen, on behalf of the state, Mr. Robinson and his legal team, and the accused, I want to thank you for your time. Many days you spent working through this important situation, important to the many victims in this case, important to Mr. Robinson, important to Mr. Pritchett. This case has been around for a while, and it required a jury to resolve it, and that was U12. So thank you for your time. I'm going to have you go back to the jury room. You'll be reunited with your electronic devices and your alternate. I need to come by and say a couple things, and then you'll be able at long last to be on your way, not having to come back here anytime soon. Okay? Thank you. I'll see you in a second.
All right,
The bailiff's ready to haul away. Mr. Robinson has been staring straight
Sentencing
ahead.
will be Thursday at 2. We will bring Mr. Pritchett and Mr. Robinson back. Ms. Mignot, I normally don't impose dates on you, knowing your schedule, but my understanding was that this week had been cleared for this trial. We found the window of, I don't want sentencing to linger out there. It's too late to do it tonight. Thursday at 2 was a window that worked. Can you make that work?
We should be able to, Judge.
Okay, excellent. All right, thank you, everyone.
Before we come off the record, Your Honor.
We're still on the record. Yes, ma'am.
We move for judgment notwithstanding the verdict at this time.
Okay, I will take that under advisement.
Thank you, Your Honor.
Anything from you, Mr. Hiles?
No, Your Honor.
Mr. Pritchett? All right, thank you, everyone.
Okay, so Mr. Pritchett forgot to join in the JNOV, which has to be done right now. And that's it. Wow. Thursday at 2 is the sentencing. No PSI needed, apparently. The alternate will be at their hooding ceremony. The judgment notwithstanding, the JNOV, judgment notwithstanding the verdict, basically you're asking the judge saying, Judge, I know that the jury came back and they returned a verdict. And instead of going with that, we would now ask that the court sets aside that verdict and that you, Judge, rule on the case directly. It's very rare, but basically if you have a jury that just, runs away with stuff and does things they shouldn't do, that would be where a JNOV becomes appropriate. But in this case, I don't see that being granted at all. What were the not guilties? I think the not guilties were not that they didn't, that those individuals were not there or something. It's that the wording of the charge and the testimony from the witness didn't match up close enough to say that matches. If you said he stole my wallet, but in the charge it says he stole your phone, it didn't match up. So yes, you were robbed, but the charge wasn't written correctly. This is on the state. It's on the state. They really should have been a little more clear. Or maybe it's on the witness. Maybe the witness forgot to say what it was, what was actually stolen. Yeah, the JNOV is basically saying at the last minute, Judge, we'd like a bench trial. Now that the jury has voted against us, we've decided to change our minds and go with a bench trial. All right. Since they're co-defendants, do they both need to request a judgment notwithstanding? Yes, they do. That because their defenses are separate. Even though they're being charged at the same time, they're almost identical. Mr. Pritchett was the only one who had an additional charge because of that first-time felony from the previous armed robbery, which he was also found guilty of because he pled guilty. Sentence, do you think will be applied? Probably a very hefty one. I'm thinking 20 plus years. Will we watch on Thursday? We're going to try. We're probably going to do some court hopping tomorrow. I'm debating doing some highlights from Karen Reed after the fact, going back and talking about some of those. But a lot of people are doing such a good job with that. I'm just not sure if that's needed. Let's see. I think that's it. I think that's everything. Wonder if they'll testify at those girls' trials. I don't think it'll do them any good, Michelle, because they've already been found guilty and they will have already been sentenced. I think the state is going to come in and say, we have enough evidence, we feel good just running with it. We don't have to give you a special deal or promise, get your sentence, lessened just to get more evidence. I mean, they've got video. They've got video of them going in. Have you shared that bunch of lyrics on your laptop? No, I haven't. I'm still working on the lyrics. Judge does decide the sentence. The jury has no say in that. They just determine guilt here. Awesome. Still nothing yet. I don't know when the girls' trial is. I think it's a couple months away, though. I'll be going to jury duty next week, knowing the outcome of this case. At least it wasn't hanging out there for you and be like, oh, how did it end? I'll never know. Like when the judge decides the sentence, they typically follow guidelines. So it's usually not a surprise as far as the judge sentence. There's cell phone wallet combinations on Amazon. So you're saying it could have been the same thing. Their deal was that nothing they said in court could be used against them. The deal the girls had was that their testimony in this trial couldn't be used against them in their trials. They're still going to be charged. They still are charged and will face a trial for those 20 charges, basically, that for what they participated in. I think it's 19 for them. No, it's too late. It has to be done in the moment. Motions have to be made in a timely manner. So I don't think so. Fun and funky, yes, you can sleep now. It's all right. Can you briefly explain the dismiss with and without prejudice thing with Mr. Kelly? I don't understand. Okay, Kenny, the state has said that they are not going to retry Mr. Kelly in that case. As part of that, they now file a motion. The written part of what they told the judge is writing a motion saying, we ask that the charges be dismissed. That's something the judge has to do. The prosecution can't dismiss them themselves, but they write the motion saying we ask the charges be dismissed. And the judge has two options when dismissing them. First of all, most of the time he's going to say yes. Okay? I don't know of a situation where the prosecutor says we'd like to drop the charges and the judge says, no, you have to go ahead with it. But the two options are, yes, we will dismiss without prejudice, and yes, we will dismiss with prejudice. If they dismiss without prejudice, that means that the court is not going to hold, the court's not going to penalize the prosecutor and say, yes, because of what happened here, we're going to dismiss these charges and you can't bring them back ever again. This guy is free. What you did to this man was awful. That's with prejudice. The judge would be saying that I'm preventing you from refiling these charges. Without prejudice, they're saying, hey, we'll dismiss these charges. We'll clear off these papers. But if you want to file new ones tomorrow, you can do that. So without prejudice, they could refile new charges, and they can refile new charges anytime during that statute of limitations. So if you are accused of a crime that, say, has a 30-year statute of limitations, and you're 5 years into it, the state might have dropped charges 5 years in and then refiled them 29 years in. And that's still out there. If you get dismissed with prejudice, which is what the defense is asking for, then it doesn't matter. There's the statute of limitations. It's over. This crime, the state got their chance and they've missed it. They've decided not to do it, and they cannot bring it back again. And it's just peace of mind for the Kellys. So defense team is going to be asking for that peace of mind, and ask for it to be dismissed with prejudice. I know Karen Reed has some audio issues that I might be able to help with, but we'll see. Might not be something I can fix. Marmaid, says, Ari, I'm fairly new here in the chat, and I must say I've really enjoyed law nerding out with you all. I'm learning and enjoying the standard vibe of the chat. Thank you, Marmaid. It's a pretty low-key environment. We like to have fun, and even though we sometimes disagree on things, we like to do it in a respectful manner, and it's wonderful. It's a great community to hang out with. Welcome. Okay. Wouldn't it be something if Kalish, the paralegal, decided to represent herself pro se? Oh man, that would be something. That would be crazy. We also like to rap and stuff. We've never rapped before this trial, but we've started rapping during this trial, so we're going to do that. Let's see, 80s Music Man. The rap he made for Brandy was really good. It was wonderful. The Treehouse Trial, 6/7, I think it is. Franklin Tucker, 6/17. 17th of, what, January, February, March, April, May, June. It's June. June 17th. I had to count on my fingers. Didn't come here to math, guys, or calendar. Uncivil cleared up the audio for Karen Reed very well. Good. I might look into some highlights. The problem is I have to first watch them. So it's assigning myself 8 hours of homework. I skipped your chat. Deanne, why did I skip your chat? Did you say something naughty? When I gave you the tip about this trial, I never thought it would turn you into a rapper. Look what you've done. Let's see. Kenny, thank you very much for the kind words. I'm glad we could answer a couple questions. If I can't answer it, usually there's some smart people in chat that can. All right. Watch out for the next album. We are going to do this trial just got it kicked off. We are going to do a rap, a LawTube rap of sorts. So let me work on that. I've got to find just the perfect way to do it. I'd like it to be my voice. There's nothing wrong with the AI computer voice, but I just think it's more real if I can do it, which means I'm a bit of a perfectionist, and it might take a while to get it going. But let's see, I think that's it. Please say weatherware if you're in Tornado Alley. Yes, the tornadoes that we've had this last week, deadly tornadoes that we've had, they're not done. There are more. We need to rap about every trial to go with the cover photo. I will save that cover photo. Thank you very much. We've got that. I'll save what we have here. 102 was the final count on the accused, by the way. All right. Airbnb gone wild. Final. Here we go. Somebody's trying to get last minute edit in. No, I won't allow it. Share, download, PNG, just this page, compress, download, boom. Okay. Good work, graphics team. Okay, I think that's all. Is there anything else going on tonight that we need to portal people to or drive the bus to? Do a quick check. Got Max Velocity doing some weather stuff. LAX is live in the airport down there. Biggin. You want to go to Biggin? Shoplifting, call 911 to avoid arrest. You want to go to Biggin and check that out? I've never, I don't think we've ever, I might have been on a stream with him briefly. Okay, we're gonna. If there's no objections, we're gonna portal over to Biggin and do that. All right, that's saved. No updates on the Maya case. I think Dr. Joe's going to be your best bet. He's got his ear to the ground there on that. I'd still have the thumbnail, or not the thumbnail, but the counter is still running on the J-Hatch counter until I'm directed otherwise. We're going to try to keep that up. Reed is live too on the weather. I don't see Brandy's. Tornado Alley is the central U.S. from North Dakota down through Texas. So basically, anyone in the middle of the U.S., please be aware. Be careful. All right. With that said, I object. I object to any objections. There we go. When you pop over and see Biggin, hit the like button. It's just a nice thing to do. Sorry, I'm reading chat. I will work on the wrap. I'll do that. You guys, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again, which will be tomorrow, bright and 30, somewhere between 8:30 and 9 a.m. Hopefully I'll have some updates on the bathroom as well. So that'll be good. Good night, y'all. Be good to each other. We'll see you. Bye.
The zombie apocalypse may be upon us.
Is that correct?
Are we going to address subject matter jurisdiction?
You're talking about stuff that is not relevant.
For the record, I don't consent to that name. I was kicked back, taking it easy.